going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? It's Tuesday, right? Yeah, happy Tuesday. Got to think about that one every time I say it. I got to think what day of the week it is. Hope you guys are all awesome. Hope you guys are doing well. Hope you guys had a great start to the week. You know, tomorrow's midway through the week. Almost made it through another week. Anyways, we're here for some court, right? You guys want to watch some court? I want to watch some court. Funny thing happened today. You guys want to see something funny? It's only a 2-second clip, so it's going to pop up here and then disappear, but it's good. You ready for it?
Howdy ho, neighbor.
I'll play it again because that was so fast. Do you guys remember last week when I called Judge Slavin out for being Wilson?
Howdy ho, neighbor.
So good. Anyways, got a special guest.
Howdy ho, neighbor. Howdy ho, neighbor.
Where's your fence?
You know what? I put it back with the rest of my granddaughter's project. So I said, "Hey, can I borrow this fence?" She's like, "Oh, yeah, sure." But it looks so good. I was so impressed at how she put it together.
Yeah. And we just talked about this a minute ago. I thought it was like popsicle sticks that were cut. No, it's actually paper. So good job on that.
Yeah, the shading and coloring and all that. I was like, all right. I immediately thought of the Wilson thing. I said, "Oh, I gotta show everybody else her handiwork there." But, good evening to everybody who's cooling with Colin tonight.
Good evening
said,
to everyone that's cool.
I gotta drop in. I just do a special surprise and say, "Hey, I'll come by."
I appreciate it. You down to watch some court?
Yeah. Who doesn't like watching court?
You know, who doesn't like working all day long and then coming home and spending time watching what you do, right?
Let me ask you this.
All right.
If a professional chef cooks all day and he's making some good grub and he's getting his Bobby Flay on, do you think Bobby Flay just like eats, I don't know, Fruit Loops? No, I mean, if you know how to chef it up. So he's going to cook for himself the same way he cooked for anybody else. So me, I like talking about the stuff. I like watching the stuff. I like sharing information about this stuff. So
yeah. I will tell you that working all day in a restaurant, first off, you eat at the restaurant. So when you get home, you're not cooking. But yes, I know what you were trying to say.
Maybe all day long, you're taking a bite of a moose bouche and here and there, a bite here, a bite there.
Yeah, that's generally how it goes. You're tasting everything all day, so when you get home, you're not hungry. But I got a question for you.
Sure.
Since you brought up food, there's been a really big debate over the last couple weeks.
Okay.
About a grilled cheese sandwich.
Grilled cheese sandwich.
Have you ever put mayonnaise on a grilled cheese sandwich, like on the outside? So instead of butter and toasting it, have you ever used mayonnaise instead of butter?
Oh, have I ever used mayonnaise instead of butter? And this was without grilling it? Or
no, you're grilling it. So you instead, okay.
No, I have not.
I spread butter on the.
I have not, but I will say this: I have had a grilled cheese sandwich that I've eaten with pickles, dill pickle like slices. And then you dip your fry in some mayonnaise. Eat with it. That's kind of tasty.
That is kind of tasty. I see where you're going with that. So the debate has been, instead of spreading the outside of the bread with butter, you use mayonnaise instead. And I'm trying to tell everyone they're wrong. And
it's
about 50-50. So
I'm not sure what the boiling point, the melting point of the mayonnaise is versus butter. I mean, butter is an oil-based sort of thing that's meant to be fried and heated up and then use that to cook other things. But then again, mayonnaise has it has its own oils in it as well, but it also has egg products. I don't know if I want to like scramble, cook the eggs inside the mayo. You know what I'm saying? I'll just stick with butter. If I'm going to grill something, throw some mushrooms in there, onions or bread or anything else, I'm going to throw some butter in there, good old-fashioned butter, and just grill it up.
Yeah, so just not mayonnaise, right? So yeah, we're on the same page. So see everybody, Judge Slavin agrees with me. All right,
yeah, we'll just keep it. We'll keep it at the. I'm not saying you can't do it.
Oh, it's definitely possible.
Like laws. It's kind of like laws. I'll explain it the same way. When you get to the red light, the first thing you do is you look up to the right. Why? Because there might be a sign. If the sign says no turn on red, then you are prohibited from doing so. But if there is no sign, then you are allowed to go ahead and do so. So this is kind of like one of those things where there's no sign that says you have to use butter or mayonnaise. So whatever floats your boat, grill on.
And I will just put my 2 cents in and say, no, when you use mayonnaise, there's a no turn on red every single time. Anyways, Mary Brown, judging judges. Thank you, Mary Brown, for the $2 super chat. And Fozzie's in the house tonight. Mayo on grilled cheese life hack. You know what?
There you go.
Fozzie, you do know that I appreciate your opinion. I respect your opinion. I just have never known someone to be completely wrong before and think they're right. Okay, let's keep going. Fozzie, I love you, man. All right. Let's see. What are we doing? We're watching court. All right, let's go.
Jazzy, are you ready on Scott Lang?
Yes, we are, Your Honor.
Go back on the record from Scott Lang. What is the any movement on this?
So I had some discussions with the prosecutor. We did all review the evidence. The prosecutor had made a remark to me that there was a question about the evidence, but the officer is present, and my understanding is that he wants to move forward with the hearing, and we are ready for that, Your Honor. I do just have a motion, though, with regard to the misdemeanor, if Your Honor would hear it regarding the discovery because of the length of time that it took the prosecutor to provide that.
Standard 21-day appeal time.
There you go, Fozzie. Standard 21-day appeal. So, question. Can you just, as an attorney, so I know there's verbal motions and there's written motions. So he just said, I want to say I have a motion on the discovery issue. So how does that work? Because I thought, so you can just, essentially a motion is you're making an argument, right? So
a motion is basically when you go and when you're a kid and you have to do something and you got to go ask your mom or dad or your guardian. So basically, so you can go to stay at a friend's house, or hey, can I go down the street? Or hey, can I have a candy bar? Or hey, can I get a new pair of shoes? Or basically, motion practice is nothing more than just asking. What do you want? Ask. And you can ask verbally on the record, or you can ask by a formal motion, especially when you get complicated motions like motions for summary disposition in Michigan. It's Michigan Court Rule 2.116C, and then there's a whole list of reasons why. So you'd pick, those. But you want to write those up. Make sure it's you're stating everything that you do and that you're looking for, and that way the other side can respond. They have a set amount of time, like you have a certain amount of time to get that to them, and then they have a certain amount of time to respond back. That way it can be kind of like the back and forth can already be played out so that the court has that. The court is advised in the premises, the words, where you've already read all the briefs. But you could skip, you technically could skip all of that and then go ahead and just have both sides just argue back and forth both sides, and then you make your ruling. Or you don't have to make your ruling. You can just say, you know what, I'm going to hold this in advance. I'm going to do some research, and then I'll give you my ruling, on Friday, or I'll give you my ruling when I give you my ruling. So motion practice is nothing more than just ask, because sometimes it's ask and you shall receive. Or like I tell my students when I'm talking about criminal procedure practice or civil practice, ask. Like if you don't know and you want to do something, ask. I want that. I want, like he's talking about discovery. I want these records. And then if they don't give them to you, then you file a motion to show cause. Like, hey, I asked for these. I subpoenaed these. They didn't give them to me. Judge, I'm going to ask you to step in and kind of pull out the mom stick and start whooping some butt and making people give me what I need, because they're not. And I have that kind of power. And then I can say, well, is it privileged or is there anything? And I can ask questions about it, or they will just argue like, no, you can't. It's work product or some other reason for like privileged information that you can't have, or it's unconstitutional. But for the most part, we have an open system of discovery in Michigan. We want to make sure that everybody, let everybody throw everything on the table. Let's go. I mean, you're going to bring it up at trial, so let's just deal with it so that trial moves quickly and efficiently and smoothly. Because you don't want to be like, all right, time out. You can even do what are called motions in limine the day of or before the trial date, which is anything that you think might be not admissible. Instead of me saying, I'd like to put in this document and admit the objection, you can have all of that stuff already taken care of and all the objections already done. So you already know what's going to be admissible. You already know pretty much what's not going to be. And then you just handle like the hearsays and relevance and those kind of objections. You can do that. It's called a motion in limine. So basically, motion practice is just asking the court for something that you want or want to have happen.
All right, that's fair. So if you don't ask, it's always going to be no. If you ask, the worst thing that's going to happen is going to be no. I get it.
Yeah. Worst that's going to happen is they say no. Okay.
Yeah. All right, let's go.
Where, officer, is that Lieutenant Miller?
Yes, that's him.
Lang. Good morning, Lieutenant. Are you there?
When I was in law school, I interned.
Go ahead. When you were in law school, you interned?
Here at the 36th District Court, the Traffic Division.
Anybody still around there? Any judges? I don't know any.
One of the judge that I won't say what their name is, but they are on TV. Who's from Detroit? Who is here, and he's very animated, and he was exactly the same way when he was here at the 36th District Court. Nice guy.
Awesome. All right. Everybody on the Mayo. Everyone's on the Mayo. And I'll explain more. But
I'm going to recognize the indigency status of anybody who has to use Mayo because they don't have any butter, so they don't have to.
I can't. That was good. All right. There you heard it. All right, let's go.
Who is this? Is this a state case or city case?
City case, Your Honor.
Have you talked to Ms. Mason about the motion?
No, I have not discussed it with her, the motion part, but about the entire case, yes, we went into great lengths about it.
All right, let's wait until she comes back so we can get that.
I'm here, Your Honor.
Okay. All right, so we're on the record with Lang. I think we just lost Officer Lieutenant Miller, I believe, but Mr. Judge is ready to move forward with his client as far as the hearing is concerned, and he does have a motion. So at this time, I can entertain the motion, and I'll allow you to respond, and then we will see if your officer comes back. If you get your officer back, I don't know, maybe it was just a glitch and you fell off the system. So go ahead, Counselor, as far as the motion is concerned.
Yes, Your Honor. So on August 8th, 2023, we had sent our request for discovery. We sent it via certified mail with the tracking number. It was received just a few days later. We did not receive any discovery before our October 12th pre-trial. So on the 11th, I reached out to your clerk and sent you an email with a draft of a proposed order to compel the discovery. The very following day, Your Honor granted it. We did not hear the state, although we attempted to reach out to them on a few occasions. I'm sorry, to the city. Strike that, to the city. On March the 12th, so just 3 days ago, I was provided with the body cam footage, and a corrupted file of the police report. It would not open. So my motion, Your Honor, is that it's not fair. We came so early here back last year. We're not provided with any discovery. My client hired me from day one to take this to trial and hold a hearing. He was pretty upset about what happened. We don't believe that we were provided the due process by getting timely discovery in this matter, even after Your Honor compelled them to do so.
Let me ask you this. Well, go ahead. Respond, Ms. Mason.
Your Honor, I don't believe that the defendant has been unduly prejudiced. I've spoken with him. He indicates he's ready to proceed. He's looked at the video. He is, his client's ready to proceed, He has been provided he has, I would imagine he has a copy of the ticket. He's told me he's looked at all of the video. And so I don't see how he's unduly prejudiced. He says he's ready to proceed. He's ready to represent his client to the best of his ability. So I don't see what his harm has been presented to him at this point.
And Your Honor, if I may. So the harm here is that allegedly the officer was working off tips, 911 calls of my client speeding. In the video, I heard verbatim that many people had called for that vehicle speeding or whatever they were alleging that he was doing. So I wanted to review those calls after learning just on March 12th that that's the basis, I guess, of why he got pulled over. So we would have had that time had they provided discovery even a month late back in November, let's just say. But we're here on March 15, 2024, only receiving discovery 3 days ago, Your Honor.
And if I may respond, Your Honor, if Mr. Haji felt that if he has all this information regarding a tip of 911, he could have brought a pretrial motion in writing. We could have had a pretrial motion with the officer to testify as to this information that he is now indicating that he has. And if it was on some tip or whatever, I think that we could have had a hearing regarding that as opposed to on the date of the trial. I think that this is late, and I think that his motion at this point is, is late when he could have brought this earlier with the court.
Listen, I'm not gonna, I don't say his motion is necessarily late in the sense that he just got the discovery according to him on March the 12th. And, we're here, what is today, the 15th. But I'm not gonna dismiss the case for the discovery issue because I'll just give you, if you need some more time to prepare, I'll give you some more time to prepare on it. So essentially, I'm going to go ahead and deny the motion for the discovery issue, and either we proceed with the trial, or I will give you and your client some more time to prepare and get those things. I will say this now that we've gone through a couple of different city attorneys, and Ms. Mason is only been here for a couple of weeks. So, and we expect her hopefully to stay. So moving forward, we're going to make sure that there's no other, if there is any other delays and these type of things like that, which it shouldn't be, then we'll address those accordingly. But if you want some time to get the rest of the police report or the 911 calls and things like that, then I'll grant you that opportunity to do so.
Your Honor, if I could speak with my client, actually, I would appreciate that before we make the decision. And I would like to know if Officer Nathan Miller is still present to move forward if that's what we decide.
Officer Miller, I don't have Officer Miller here. I don't know if you have Officer Miller's number. Officer Miller was in the room, and I tried to move Officer Miller to the main room, and he's gone, and he hasn't checked back in. So,
Your Honor, I would then, if Your Honor, motion regarding that issue.
I didn't hear into that, Councilman.
Yes, Your Honor, I would have another motion then regarding the officer's presence, if you would be willing to hear that.
Dismiss it.
Well, I'm going to definitely hear that in a few minutes. I'm going to give the officer, and just to make sure there was not a glitch on the officer's end, I'm going to give him just a few more minutes to show up, and then I'll definitely hear that motion if they don't show up in a reasonable amount of time. I'm going to put you in a breakout room with your client, and then I'll allow you to speak to your client. And then we'll see if Officer Miller shows.
Thank you, Your Honor. We appreciate your time.
All right.
All right. So all that happened, and that case was dismissed. It came back up in about 2 seconds, and it was gone. And I thought I had it, and I didn't. So nothing happened. It just they recalled the case. The officer wasn't there, and they dismissed it. So all that argument, the officer wasn't there, then they dismissed it. So just so everyone knows, I don't have the end of that, but that's what happens. But the next one is the next same prosecutor, a different defense attorney, kind of the same battle with the same argument. But before we do that, all right, we've read that one. We're going to read these super chats real quick. Read that one. Grilled cheese mayo, correct. Grilled cheese with tomato and pesto. 407 levels wrong with that. You've never had it then. You've never. Marco Foods, I love you, but you haven't had it if you're saying 407 levels. Now, if you said 2 levels, that's fair. You might not like pesto. You might not like tomatoes, but delicious, delicious. All right. Fozzie, I still don't know what the hell pesto is. Yeah, that explains why you put mayonnaise on grilled cheese. Right there. All right, legal fiction, filing fee for my motion to vacate the Mayo verdict. All right. I appreciate it. Judge Slavin, what do you think? Accept it or just deny it outright?
Accepted.
Accepted. All right, it's accepted.
For the reasons stated on the record.
All right. Sounds like we're going to have a hearing. We're going to have a hearing Monday night. Speaking of which, the grilled cheese thing. We got into this argument about mayo versus butter. And I don't know if you remember from the first time I met you, but I've worked in the restaurant industry for about 18 years. And so I'm very against mayo on grilled cheese. So that's what this whole thing is. So I am going to be making on Monday on my members only stream. I'm going to be making my favorite grilled cheese with butter, and it's going to be delicious. So that's what the whole pesto thing is, because I put pesto on my grilled cheeses.
Okay. Steps it up. Trying to elevate
It does. Mainly because I'm not a child, so I like to put some extra stuff. I love a traditional grilled cheese, but when I'm making it for myself for dinner, like I don't want just white bread and American cheese. Otherwise, I will do that if I'm dipping it in soup. But if I'm just making a grilled cheese, I'm gonna make it a sandwich. And we both love sandwiches. All right. Flying Monkey, thank you so much for the 10 gifted memberships. Welcome to all the new members who received a gift. Members only Monday. I'm going to be making grilled cheese. There might be time for court. Grilled cheese only take about 10 minutes to make. So, yeah, we'll see. Fozzie's back. Fozzie's cat is back. And want to make sure Colin has money for mayo on Monday night stream. Thank you so much. Not doing it, but thank you so much, Fozzie's cat. Jedi. YouTube won't let me say what I want to say, but it involves a cat, an open hand, and a female dog and butter. All right. YouTube won't let me say what I want to say, but it involves a cat, an open hand, and a female dog and butter. So what it sounds like is you want to slap Fozzie across the face is what I'm getting at that. So that's what I'm going with. I have no idea. So female dog, clearly. I don't want to say that because we're doing really good right now and not cussing. So we're going to keep that going. Involves a cat, an open hand. Yeah, I don't know. Any guesses, Judge?
I will refrain from any commentary about the thing.
That sounds like you know. I just don't.
That's what Jawbone says. The Jedi tricks will never work on me.
And legal fiction for extra butter so you don't resort to mayo. Thank you so much. Also, did you see the comment I pulled up when you said when you use mayo, you're indigent? And someone said, ha 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 ha. If you're using mayo, that means you get a public defender.
That's right.
Yeah. Straight from the judge's mouth. That was awesome.
All right. If you're using cream cheese, you're just going to be probably improper. And the cream cheese comes directly from Morocco. And
speak now. You said that. How do I share this? No, I'm not going to share it. I wasn't to share the meme I sent you. I put it on Discord, but I don't know how to do that quickly and bring it up on the screen, so I'm just not even going to bother.
All right.
But it would have been perfect for right now what you just said. But yeah, so if you use cream cheese, I hope you're wearing a fez. Otherwise, you have no right to use cream cheese on a grilled cheese. All right. So let's go. Same court, same day. This is about an hour later.
I'll grant that motion on SP 107-71451, and the other cases are going to be set.
Your Honor, and I will also request that discovery for Mr. Lewis and for Mr. Olenichek be sent to me before we start.
I would object to that motion. We have under the court rules 21 days to provide.
I didn't make a
Never sent the
motion.
recovery.
I didn't make a motion. I made a request. There's a difference.
Okay, well, we're not providing it at this point. We're not providing it under the court rules. We have 21 days.
Let's stop. All right. Well, Ms. Mason, this is the time set for trial. So somebody should have been apprised and had some motion, some discovery today. I mean, it almost touches on the same thing that Mr. Hijazi was talking about for his client. But at this point, there's absolutely no discovery.
Mr. Jazzy was the attorney from the first video. So that's why this kind of feeds right into that last one.
If I may, Your Honor, interject, I think that Mr. Hijazi can be distinguished because Mr. Hijazi had been diligently requesting the discovery. And that is a difference here. And in which this person has had an opportunity at the pretrial point. They could have appointed counsel. Counsel could have requested discovery, which is usually a manner, especially with cases like this where the issues are serious. We're talking about a 6-point. Nobody appointed counsel to provide us with this. And as the court knows, we have countless cases where it's hard for us to keep track. So that's why we do the process of having the appointed counsel. So an appointed counsel can ask us for discovery and we can proceed in a timely, orderly fashion, Your Honor.
All right.
And all that being said, today is the date and time set for trial and or formal hearing. I find it very hard to believe. Yes, I'm sorry.
I apologize. Which case are we on? Because we spoke
I'm
about.
sorry. Let's go back on.
You know it's bad when the attorneys just start going at each other before the court reporter even know what's going on.
I was waiting for someone to start going, Jerry.
Somebody.
That's from your neck of the woods, right? He was the mayor there?
He was the mayor of Cincinnati for a long
Was
time.
he like a big statue or something? Like, Jerry.
No, there's not a big statue, but we do claim him. We do think it's hilarious, and we also think it's hilarious why he was forced to resign.
I mean, as far as making something new and different, I mean, that was probably one of the first shock type things going on back then. So yeah.
And he was still very much into politics after he started the show. He would come back to Cincinnati and advocate for his friends. He would go to the rallies with them. He didn't leave politics just because you obviously know what I don't know. I'm not going to say obviously, but do you know why he had to resign from the mayor of Cincinnati?
I don't. I mean,
he purchased a Lady of the Night with a personal check.
Okay. Well, he didn't have Venmo back then, so
there was no Venmo. Yeah, so yeah, it came up. I think she started to try to extort. I don't remember exactly the story, but there was proof, and he's like, I guess I can't be mayor anymore. I guess
I don't think he could have done the Wimpy thing.
All my other dream
Tuesday for some
right.
carnal knowledge today.
Yeah. Also, hashtag not legal advice, but don't pay your ladies of the night with personal checks.
Yeah, I'm not saying that or commenting on that.
All right, let's keep going. I don't want to make this turn into something.
Sure. Yeah.
But you brought up Jerry Springer, so it's your fault.
It's true.
On the record with Mr. Javon, we're on Javon Edward Lewis.
Oh, okay, thank you.
Go.
I actually think that's exactly what happened. He put a stop payment on the check, and that's when she came forward and did it. I think that's the story. I think that's the story. I think you're exactly right, Hector Cam Clips. There was something weird about it, but it had to do with the check. But I think that's exactly what happened.
Go ahead, Ms. Harris.
Today is the date and time set for trial. I would find it hard to believe that a trial will move forward with no type of evidence and or discovery available at trial date. I find it hard to believe that if we've reviewed it, we can't just provide a copy on the date of trial to defense counsel for an indigent defendant. So are we saying that indigent defendants are treated differently based on the fact if they have an attorney or not? Because a lot of people come to trial date and don't have an attorney appointed or don't retain counsel. Arguably, we can move forward with the trial today. I believe discovery should have been made available.
All right.
It's trial
If I
date.
may, Your Honor. If I may, Your Honor.
Hold on. Let's just now go ahead, Ms. Mason.
On a formal hearing, Your Honor, which is a civil matter, they are not provided discovery on a formal hearing. So on that matter, she would not even be allowed discovery.
Well, we're talking about all of these are well, not all of them, but there are only 2 formal hearings. It's trials for the 3, and it seems like they're all related matters, all happen on the same occurrence. So therefore, I would think that, in that discovery pack, there would be something to touch on, the formal hearings. But at least if we don't even address those, we're talking about the trials for what is that? Leaving the scene of a personal injury accident, driving while license. And as far as Ms. Harris is concerned, she's saying, I completely understand with her that we don't have necessarily appointed counsel for everybody, and people do set their trials. I see the system as kind of a kind of big hole in the system, in the sense that because Mr. Lewis is Mr. Lewis in the room yet? Because Mr. Lewis doesn't have his own attorney, that he can't get the discovery in some kind of way. That's gotta be fixed. It's gotta be fixed. Now,
I wasn't waving at you. I was commenting about the typing noises.
Yeah, I was. I don't know if they're typing with 2 hammers and one in each hand, or
That's exactly what they're doing. She's really good at typing with 2 hammers. Like that's impressive.
Ms. Harris says she's ready to go but she will need something to operate off of. What is the issue in getting something to her so that she can review with her client as far as the allegations are concerned?
At this point, the assistant who would do that is out to lunch, and I don't know when he's going to return to even get that to her.
My question would be, I believe the City of Detroit's law department has reviewed the discovery. I think it has been made available to them. I'm sure why that can't just be forwarded to me.
As I have just said, my assistant who does that information, who does that, is out to lunch. I don't know when that person will come back. I do not have the authority or the capability to get it to you.
That's not answering my question. My question to you is, have you reviewed it? Can you forward what you have reviewed?
I cannot forward what I have reviewed. No, I cannot. That can only be done by our assistant.
Well, why can't you re-forward that, Ms. Mason? What's the problem with forwarding that?
I think it's some encryption stuff, Your Honor. It's just some encryption kind of stuff that goes on.
Okay.
That's computer lingo for I'm not doing it. If it's encryption,
not my job.
she can send Yeah, she can send it to the public defender's office. I'm sure if there's end-to-end encryption that you have to do, the public defender's office already has the key to open it. So, yeah.
Just forward the email.
So,
Yeah, it's Prosecutor Mason. She's usually really cool, calm. And as I was telling you before the stream, she's in 3 or 4 courts at once. She generally has on multiple different headphones, and she's like spinning around in her chair. She works her butt off.
Ability to multitask. It's good.
Yeah, but I've never seen her like this. I've never seen her get upset. I've never seen this out of what I don't know. I've been watching her in multiple different courts for about a year now, and I've never seen her lose her cool before. So just like, what is going on? You know, some people have bad days though. Some people have bad days.
It's true.
No, okay, that's not true. Everyone has bad days. Just unfortunately, you know, this is on YouTube, so
we have a problem. And this problem, it seems like it's Mr. Ajazi has brought it up in his client's cases. It seems like the city of Detroit has an issue with getting the discovery, because in Mr. Lang's case, he has a retained counsel that has requested multiple times for discovery, and just got it on the 12th of March. And the date is the 15th.
And I will just add, usually when we are sent our discovery, it's sent in such a format that we're able to forward it as well. So I'm not certain why it can't be. It gives you the option to view and or share and or to download. It can be sent. I think it's a matter of it's just not going to be sent, not that it can't.
Plus, if you're on Zoom, you can just share screen it. I mean, if you had to.
yeah, you absolutely could. There's no reason why. It was driving with a suspended license, I think, and there was another charge. It can't be more than what, a page or two? You could just share it on Zoom.
Yeah.
I don't know how many pages Discovery is.
Well,
but
the driving while license suspended is basically the only thing you really need is a certified copy from the Secretary of State showing that they got notice that their license had been suspended. And then you just need the officer's testimony that, yeah, they were driving the car. There you go. Ta-da. I mean, it's not
done.
Proof case.
Detective Rachel, hello. I stopped the stream just for you to say hi to you. Judge Slavin, can you please say hi to Detective Rachel to make her night, please?
Detective Rachel McCrae, good evening.
All right. We stopped the stream. We said hello to you. I tease her every night. This has become a thing, and it's kind of funny.
All right. So is there a motion? What is going to happen here?
I would move to dismiss.
And Ms. Mason?
I would object. I believe that the time has not come. We're just now getting this request for discovery. We don't have 21 days. That would be.
I'm going to go ahead and in this instance grant a motion to dismiss. The reason being is that we are set date and time for trial. It's just not sufficient with the court to say that we can't get it. If she's requesting it now, is willing to go ahead with the trial, despite the fact of just getting the discovery right now at on the date of trial, then and the city still cannot provide it. The city's going to have to figure out a better way to handle these cases moving forward, because I'm going to dismiss the case, grant the motion to dismiss based on the discovery issue.
They can always refile.
Yeah, they absolutely can. Would you driving with license suspended, is that a typical case that gets refiled?
Mm,
It just seems like a lot of
I've
work
never
for.
seen, I've never seen one. I've never seen one be refiled. But then again, I've never had an issue with discovery on one where I had to dismiss it. So record keeping, and listen, I mean, Detroit is a big city. Um, they have a lot of backups in the Wayne County Circuit Court. For example, like front of the court, trying to get modifications on child support, custody, things like that. But what people don't realize is they have like the second largest volume of cases in the country. Second, I think, at least at the last time that I had checked, second only to Los Angeles County in California. So when you have that many cases that you try to process, it might take 6 months to get your case heard, to get in there in the court and have it heard. Whereas other places, yeah, maybe it's 2 weeks, maybe it's 3 weeks. You file a motion, you file for a hearing, you get your hearing date, boom, you're in. So having interned at 36th District Court for the prosecutor's office, one of the hardest things that I found was being able to put your hands on discovery, especially like in drunk driving cases. The data master information, where's it at? Like constantly was never there. And I'm like, well, it's going to be a little hard to prove this drunk driving case when, gee, I don't know. Nobody has any of the documentation that the data master was valid, that it had been updated and it had been calibrated and tested, because you have to do that periodically. There's a time frame, like, that you have to show that that's been done. And if you can't, then because that goes towards credibility. You're not going to let evidence in if it's not, if it's not accurate and it's not, and it doesn't, purport to give you what it's supposed to be giving you, because you can't trust it. It's the same reason why lie detector tests are inadmissible, because they're just not trustworthy. They're not as accurate as they really need to be. So yeah, same with breathalyzer, roadside PBTs, not admissible. Why? Because they're not scientific enough. So, and you can't really lay a foundation for them. So that was one of the biggest things. And as a judge, that would have to be very frustrating. I think the judge handled it well, and I would have done the same thing. Err on the side of the Constitution. This person has a constitutional right to be prepared. Their attorney's asking for stuff. Today, not tomorrow, not next week. Today is the day for trial, and I still don't have the discovery. I mean, yeah. So dismissal. Hey, if they want to refile, go refile. If not, then I guess they don't. But
Yeah, that makes a lot of sense. This video is only half over. I thought that was it. I don't know what else I have in this video, so I have no idea what's about to come. But so I'm gonna play a little bit of it and see what it is. But I have another video I want to watch before, and that's the one I told you about. But Rachel, I did see that case, and I do have it. I am going to wait till next Wednesday for the hearing, and I'm going to play them both back to back. Next Wednesday is my birthday, so it's going to be my birthday stream. There's a crazy case today. That's what she's bringing up. So Rachel, yes, I definitely got it, and I'm going to play them both back to back next week. All right, let's see what this case is. What is this?
All right, Chris.
We're still back in Perkins. All right, I think we've had enough Perkins. I don't know what this is. Let me just fast forward. Oh, he looks animated. All right, I'm gonna go back and check what that is later. But we're gonna jump courts. We're gonna jump to Judge Goggins.
Let's see. How about?
All right, this one is this one's fun, and I'm gonna pause it here shortly and let you guys in a little something. I'm just gonna say, if you have bingo cards, get them out, because everyone's gonna have a bingo. All right, 2 pop for $10. Do we know a justice of peace that has a connection to encourage Judge Webster of Kansas for an interview soon. I don't know. I have been in contact with somebody over email that said that that's a potential, but I haven't heard a week, so that's still in the works. It could happen. I don't know. Just got to let things play out. But thank you for the $10 super chat, Tupac. Also, Fozzie, I didn't miss this. We're talking this. He said this during the Jerry Springer talk.
Yeah.
All right. Yeah, get your bingo cards out because we hit a trifecta here shortly, and you'll see it. You'll see it.
NDB LLC versus Kyrie.
All right. First off, woman in the top right. I can probably recreate that. Hold on. No, my hair's too thick. I can't recreate it. I really wanted to, though.
Chris Wilson or Naylor. Mr. Fanous?
Good morning, Judge Elias Fanous, appearing on behalf of the plaintiff.
Okay, and I should have Kyrie Naylor. Was here?
I'm here.
Great.
I'm here, Your Honor.
There you are. Yep. Mr. Fanous, this has been adjourned a couple of times, it looks like.
Yeah, I know I was in trial. The last time it was up, I had Attorney Bernash cover, and then it was adjourned to today's date. This is a termination tendency, Judge. I have not had an opportunity to speak to Kyrie, but if he wants to speak to me in a breakout room to try and resolve it, I'm happy to pass the matter and allow me to chat with him regarding the case.
Mr. Naylor, do you want to do that?
It's a retaliatory eviction. I do not want to do that.
Okay, well, if you talk to an attorney?
No.
No?
Coming out
It's been
strong.
adjourned several times. I guess we'll proceed at this point then. Mr.
There is absolutely no harm with going into a breakout room and talking with the other side during a landlord eviction. When people say no, it's like, oh, this is going to be good. I start paying attention when like, no, nothing's going to happen. Like, oh, there's going to be a fight here, and I'm paying attention.
Denise, are you taking testimony? Or we got somebody else? What?
I guess I can give testimony, Judge.
I want to speak to legal.
Well, sir, you had a chance since February 20.
I've never had the chance. I've never even seen this lawyer. My name is no.
Hold on. I adjourned it from February 27th. At that time, you had your rights given. I asked you whether or not you wanted to talk to legal services. I've got nothing on here.
That sounds like a valid complaint to me. They're evicting me because I didn't pay rent. They're evicting me because, they're retaliating against the fact that I didn't pay them what I told them. That's retaliation. I agree, Johnny May. I don't see any problem with that at all.
See, a retaliatory eviction in the state of Michigan is actually under statute. Basically, if I'm renting from you and Colin is my landlord, and I'm not exactly cooling with Colin because Colin won't come over and fix the damn sink that keeps backing up, and I've asked him to say, hey, dude, this thing's leaking. You're supposed to be taking care of the maintenance of the place. I put in a work order 3 times. I'm not getting my bang for the buck. See, when you get an eviction, the reason that the landlord files for the eviction is that basically all it is just a breach of contract. I'm giving him a place to stay. You need to pay me. On the first of the month, you need to pay me every month. But it's not just a matter of a place to stay. Like any good contract, you have a warranty for things. When you buy a car, when you're selling a car, you're warranting that, yes, this actually works. You can drive this car. If you don't, then you can run into lemon lawsuits where you're going to be sued for fraud or some sort of fraud in the inducement. When it comes to the warranty that comes with a tenancy situation, when you create a tenancy, which is the right to use property in certain defined terms under the lease, the warranty is what's known as a warranty of habitability. You're giving me a place to live, but it has to be livable. a lot of times people will bring that up and they'll be like, oh, this is horrible. And it's got fleas and there's rats and there's this and there's that and there, but et cetera and et cetera. And I say, where did you stay last night? Oh, at the place. Well, it's a little hard to claim that it's not habitable when you're habitating in it. So it ain't that bad. I mean, like if you got to leave, if there's a gaping hole in the ceiling and every time it rains, it's literally raining in on you, that's not a place you want to live at. That's not livable conditions. So you had to leave. So no, you shouldn't have to pay rent if you can't even enjoy the premises that you're technically renting. So a retaliatory conviction is when I say, hey, I need you to do stuff, or you basically make a complaint to the Better Business Bureau or anything else, or somebody else. If you're making a complaint and you're like, okay, fine, you know what, then I'll just throw your ass out. Why? Because I asserted my rights. It's basically that's where there's actually a statute for retaliatory termination of a place.
This is why I want to play a landlord-tenant case with you. For the chat, for everyone who doesn't watch Judge Slavin every day, he is an expert at landlord-tenant cases, and he goes through them faster than any other judge. I love Judge Goggins. He might have the calmest voice out of any judge I've ever heard. He's just so calm, pretty much monotone most of the time. He gets a little upset sometimes, but rarely. So it's just like you're listening to him and you're kind of falling asleep. Like, get upset. Just get upset once, so to wake me up sometimes. You'll see it during this one. He raises his voice from oh, please don't talk to me that way to please, you need to stop. Like that's about as high as he goes, and it's awesome. We're gonna see. This is a
Michigan courtroom. Okay.
Yeah, it's Michigan. I don't know where Judge Goggins is. I don't know what part of Michigan he's in. My chat, generally when I say I don't know, the chat will bring it up. My rent for space in your chat from Mark Surfer. Like, thank you, Flying Monkey. I very much appreciate it. And thank you for the gifted subs earlier. You were awesome, Monkey. All right, let's keep going. This gets so much better. So much better.
My name has been wrong the entire time. The case has been dismissed.
And I straightened it out. That's right. You and I talked, and we straightened it out the last time. I've got Kyrus Wilson, also known as Kyrie Naylor.
No,
we've talked.
67.
It's not also Naylor. He has my name wrong, and that's their.
What's up, Judge?
67th District Court in Flushing, Michigan.
Oh, you just looked him up?
Yeah.
Flushing. Where's Flushing? I don't know. Is that northern? I don't know where that is. I have no concept of where that is in Michigan.
Yeah, Flushing is sort of like by Flint, I guess.
Okay. All right.
So
yeah, you got the hand. I know. Yeah. I should have just asked that. I should have done that. Where on the hand is it? Whenever you ask where a city is to a Michigander, if you say where is the city at, they're gonna go.
It's true.
All right, let's go.
Fault is not Georgia.
You and I talked, didn't we?
No, we didn't actually, Your Honor.
We did, sir. My notes.
Well, I have everything recorded, Your Honor. You've never asked me that I want legal.
We're gonna continue. I'm gonna base it on my notes. Mr. Fanous, are you taking testimony then? Is that what?
Judge, yeah, I can give the testimony to the court. Absolutely, Judge.
Why don't you raise your right hand, Mr. Naylor? Raise your right hand for me.
I want to speak to the attorney then.
Do you swear from the testimony you're about to give will be the truth?
I do.
Yes.
Okay, Mr. Fanous.
Thank you, Judge. This is an action to recover possession following a termination of tenancy. Notice was properly sent by my office on January 19th to the property located at 2341 Mallison Avenue, Unit A. I signed it myself, Your Honor, and I physically mailed it myself using our postage machine here in the office. Mr. Naylor is still holding over following expiration of that notice to quit. We are simply just seeking possession only. We're asking for a writ to issue in 10 days.
Okay, when did I guess rather than me fumbling through, when did it expire, the lease?
I do not have a copy of the lease with me, Your Honor. The notice was mailed out on January 19th, giving Mr. Naylor through February 19th to vacate. this action was filed subsequent to that date.
Okay, let me just look at I do have a copy of the lease agreement as well. It's made January 2021.
I didn't see a print name on it at all. It's on the front of the fucking lease. Is there a printing? Well, the lease was fraudulently, I didn't print my name on the lease. The only thing I did was sign. And that's what it was.
I didn't print my name on the lease. All I did was sign. All right, first off, how long does it take you when you hear someone chirping in someone's ear? How long does it take you to shut that down? Would you let it happen once or twice before you?
I literally when anytime someone's like looking off, like getting their cues of what to say from I just stop and go, who are you talking to? Like, turn your screen so I can see who that is, or tell them to get next to you. Because if are they an attorney? Who are they? What are they? I go, because you know what? I'll just set it for in person. Everybody come on in here so I can actually see who's talking. I don't want somebody else testifying and basically holding up signs like, yes, no, don't say that. I mean, that's the one thing that Zoom, and we have to be very cautious in the judiciary to make sure that you're not getting a bunch of lies and coaching, and that's why, like, for example, in almost every case, you want to sequester witnesses. All the witnesses who are going to be called upon to testify in today's proceeding will wait out in the hallway until they are called upon to testify. Why? Because you don't want everybody matching up their stories.
Right.
I'm going to listen to you testify. I'm going to be like, yeah, it's kind of like what Colin said, pretty much the same, and so that's why you haven't went out. But see, now if they can just watch a live stream and be out in the hallway and they already know what you said, they can watch the live stream on their phone. So I have to add the fact that it can't be on your phone or any other device, that kind of thing. So it's hard when you're not there. You don't know who's talking or who's talking to them or passing them notes or, trying to coerce the conversation in a certain direction. That's not what justice is about. The scales of justice take offense to that.
It's understandable. I get that. Yeah, I see it every day. It's just generally it's someone's parents, and I have a clip. I actually might have put it in this video. It might be at the very end, where there's another judge out of Detroit, who has a tally on somewhere on her desk. She has a tally where she has to stop her hearings or her proceedings to ask who the person's talking to, and if it's mom or if it's dad. And we're in March, and I think the last time she said it on YouTube was, I've got 12 for mom with the son, and I've only got 2 with dad with the daughter. So it's kind of a funny thing. She has fun with it. But yeah, so that's generally when you hear chirping, it's generally a parent. But this guy to be telling him what to do. But that's why I asked the question. Anyways, I'm rambling. Let's go.
That's why they have Wilson and not Naylor, which is a completely correct name.
Mr. Naylor, you just need to wait, let the judge do his thing, and then he'll you.
What do you expect? I can't cut off people.
Hold on, Mr. Naylor, you gotta let me see what I've got first. Okay?
Okay, Your Honor.
All right, hold on just a minute. I'll get you a chance.
Right. No one can hear you. It's not like your square is showing green right now. No one knows that's where that's coming from.
We can't still miss that. Okay. So anyway, I have it on good authority.
I've been in good authority that someone's talking to you. No one's talking to me. I don't know how long this break is. Judge Goggins just going over all of his paperwork. I don't know how long this break is. I think it's only like 30 seconds, but yeah, I do like this judge. He's very kind.
Yeah.
and he doesn't come down on people. Never, like right now, like this is about the height of his frustration level that you see. It doesn't work with a lot of people. Some people need that. Like this guy, I think he needed a little
It looks like this was
raised
a
voice to
lease that was done by
get that guy out
a
of the room.
person of some sort. But at any rate, it looks like the term of the lease says lease agreement was made third. It looks like a three day of January 2021. There's no end date, so it looks like it's a month-to-month lease agreement with payments of $650.
Your Honor, I have proof of everything.
Okay, I'm gonna give you a chance to talk. Hold on, I'm just looking at what's been submitted. And then there's also in paragraph 14, Mr. Fanous, just so I don't catch you off guard either, there's a paragraph 14 says lease with option to buy, but I don't see anything beyond the right to purchase with tenant will have first opportunity to purchase said leased property upon written notice of interest. Transfer. And that's all, that's basically the foundation. I guess Mr. Fanous, from what you're hearing, any objection to what I've just read off of that?
No, Judge. I know I reviewed that lease before filing, and which is why when I met with Mr. Berber, the owner of NDB LLC, I suggested if he just wanted to move on from this tenancy, to send a 30-day notice to quit.
That's my email, and it just loves going off while I'm watching court. Just ding, 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 ding. You know, when I'm watching court and I'm just relaxing, it never goes off. It's when I'm.
You know, they have this button called like this notification thing. You can like put a check mark next to the ones you want and not one.
I don't know what that means.
Oh.
Yeah, that's a thing. Like you can actually stop that. Yeah, I know.
It's here. I mean, hold on. What's that? Yeah, you can just go into the settings. According to my source over here, you got to go into settings, notifications.
All right. For that. Here we go.
Howdy ho, neighbor.
Howdy ho.
He did for him.
Yeah.
Howdy ho, neighbor. All right, let's go.
Okay, so Mr. Naylor, back to you now. What did you want to tell me?
The lease is fraudulent. This address is not even under his LLC at all.
Mr. Naylor, hold on. Who's with you? Who's giving you advice?
Okay.
Who is it?
I'm really just recording.
Well, no,
you're not allowed to record this session, sir.
Yes, I am. I have a First Amendment right.
Sir,
no, you don't, sir. You are committing a felony right now. I would suggest you stop.
NDB does not own this property at all. We've already went to the deeds and pulled up everything. This property is not under NDB at all.
Naylor,
it was rejected.
Who's with
you?
It
was rejected due to a wrong address and legal prescription.
Mr. Naylor, there's somebody with you. Who is it?
My father-in-law. I'm his father-in-law, Your Honor.
Hold on, you guys are going to make me upset.
I'm sorry.
Hold on, you're gonna make me upset. Don't do that. You don't want to see Judge Goggins upset. He's gonna raise his voice from, guys, you're upsetting me. Hey guys, you're really upsetting me. All right. So remember when I said get your bingo cards out? This is why. Top right, passed out. The left, the guy. Okay, he just took the puff. You can't see him. Right under Judge Goggins, guy with a hat that's smoking, and then we have a ceiling fan. Trifecta right there. You know, actually just four. So. Someone might have just hit bingo if you had your bingo cards out.
Nobody was with you.
I never said anybody wasn't with me.
Yeah. Why don't you do this for me, Mr. Naylor? Get your head on the screen. We'll put the screen down. There you go. I want to see your full face.
Right here, Your Honor.
Okay. Raise your right hand for me. Do you swear from the testimony you're about to give will be the truth?
It's the truth.
Okay.
Yes.
Without any anybody telling you, anybody in the room, otherwise I'm going to have them step out. What did you want to tell me?
I want to tell you that I've started withholding in this, I want to say December, because it was mice running around here. I found mice poop in my daughter's crib and all type of stuff. So I started withholding rent, and then he took action because I withheld rent, which is a retaliatory eviction. And
so I understand you didn't pay December's rent. Is that right?
Correct.
Yeah.
Yeah, isn't that what escrow is for? You can't just say, I'm not going to pay rent until you fix this. So how easy? So let's say I did have a problem with my landlord, and let's say, so today's the 19th. I'm not going to pay April's rent until this problem's fixed, and it's been going on for weeks. How easy would it be? I know I'm in Ohio, you're in Michigan, so it might be a little different. If I went down to the whatever courthouse is in the jurisdiction, said I want to start an escrow account for my rent, would they almost immediately approve that and then look over what's going on, or would you have to go to a hearing before they approve that?
So without I'm not giving any legal advice, and this is just a hypothetical.
It's just a hypothetical. I love my landlord. I've got no problems here.
I'm going to go back to the hypothetical where I am the tenant and I rent from you. Okay. And I'm like, hey, dude, this isn't working. The plumbing's not working. The air conditioner that was supposed to be in here is not working. There's a hole in the roof. The roof is leaking. And you're not doing anything about it. Okay. Now, retaliatory eviction comes from when you try to evict me because, I don't know, I call the city and say, hey, when was the last time this place was inspected? I need to get a building inspector out here because this place is in a lot of violations. It's not my house. And or maybe it's not even listed with the city. Most cities and most taxing authorities want to know if a house is a residential house or if it's a rental house. Because if it's a rental house, I know you're going to be paying more of a percentage in your taxes. Why? Because it's kind of like a commercial property. You're running a business there by renting it out. If you actually live there, well, then it's your homestead, and it's going to be less in Michigan. But a lot of cities charge you a higher percentage on the tax rolls for your property if you're renting it out. It might not actually be listed as a rental. So you go and report. So I'm going to go and report that to the city. Yeah, Colin, he's renting it out to me, and I don't even think it's listed as a rental. And so then they look it up, and they're like, oh, hey, hang on a second. How long you been renting? Oh, a couple of years. Well, Mr. Crow, you owe us a percentage of money here that you weren't paying because you lied to us. And then you're like, oh, okay, Slavin, I see you. All right, so how you like these? You like apples? I like these apples. You're going to get tossed down in your ass because I'm going to file an eviction against you. You can't. That's a retaliatory conviction or eviction. You're literally only doing it because I basically ratted you out. I called the city, or I called the local government authority, or the village, township, or whatever other government that's there. And so when you have a contract, a normal contract, you can't just breach a contract. Now, if the other party has already breached first, but what you should do in a landlord-tenant case, what I would do, what tenant Slavin's going to do, is I'm going to go to my local municipality, and in Michigan, the district courts have absolute jurisdiction over all landlord-tenant cases. Doesn't even matter if it's $1 million a month. If I want to rent a place for $1 million a month, it's still my call. Why? Because district courts are smaller, and the chunks of land that they cover are smaller. And like when I have somebody telling me, hey, I live at 9475 Beach Daily Road. And all right, so that's 5 houses south of Wick and Beach Daily. Okay, I know exactly where that house is. Like, I know why, because I've lived here my whole life. I'm aware and I'm familiar with the property. And so when I would go in there, tenant Slavin's just going to file a landlord-tenant case. I'm literally going to file a case myself. Just like the landlord files the case when the tenant's not paying, flip it around. The tenant's going to come in there and say, hey, he's not fixing anything. I want out of this lease. I'm not paying for the stuff and I want out of this lease. And you file a complaint to do that. So, and then they can counterclaim, they can counter sue and say, he hasn't paid the rent and he should have. He owes me for like 6 months worth. And then the judge will figure it out. This guy here, I don't know if he filed a counter complaint, but you can file a complaint for retaliatory eviction. And you can, this is in landlord tenant cases, this is where the power, the court's equity kicks in. I mean, it really is shown a lot, because a lot of times equity is just like the first rule of equity is let that be done, which ought to be done. Courts in the United States are courts of law and courts of equity. But if there's a law, a statute, that statute controls. Equity loses out to a statute. If the legislature said this is what the rule is on this, equity doesn't kick in. But in landlord-tenant cases, they left it sort of vague so that the courts can like figure it out, like do what's right, make sure that everything gets done properly. And I can see, are you really throwing somebody out because they're not paying? Or are you just being a dick? Are you like literally trying to like, okay, well, you know what? I know you got nowhere else to go, so I'm just going to kick you out of here, homeless. Guess who's going to be homeless in about 3 seconds? Here you go. And that's why they have those things. That's why they use that. That's why they have these statutes that create these causes of action. So even if you don't file an actual counter complaint, you can raise that defense at trial, like he's trying to do. He's trying to say, look, there's mice. I got mice in my daughter's crib. I mean, yes, you can still go to ACO or Home Depot and buy some, mouse traps. I mean, that's not, but that's something that the judge could take into consideration on this. You want to weigh all those things out and see what exactly is going on. You can't just not pay, but at the same time, a lot of people don't know that. So if you want to, you can ask for an escrow. And say, look, I'll pay, and I'd like to pay into the court. The court has escrow systems set up for that. And a lot of times in a landlord-tenant case, you can ask, the landlord can ask, hey, while this case is pending, Your Honor, I'd like for them to pay into escrow. And if I think it's appropriate, I'll order that, and they have to pay in the meantime into escrow. Then once the case is done, we'll figure out who gets the money.
Do you need a court order to open an escrow account with the court?
Pretty much, yeah.
Okay. I hear the question I've heard the question asked when I've heard a lot in front of Judge Simpson, where the tenant will be like, I'm not paying rent until this. And he'll say, well, do you have an escrow account? So obviously he knows the answer to that question. I don't know if that's just kind of like, you're not doing it the right way.
Sure. If you want to on your own, there are escrow companies that you can go to and say, hey, I'm going to pay my rent into you guys. And then a representative from there will either sign an affidavit or show up at your hearing and say, we've been holding this money that they said they asked us to hold on to until this case is decided. And the judge can recognize that escrow as being, okay, well, then if that's really, just keep paying it into that then. But if you don't have an escrow company, you can pay it into the court. Just like bond money. Bond money is no different sort of than that, like escrow. We're just going to hold that money, make sure you appear, and then here's your money back. You appeared at all your court cases. So,
all right, fair enough. Thank you for answering this. I know that went a little bit lengthy, but yeah.
Yeah, but it's because it's a kind of a technical. Because what he's saying isn't any like sob sit thing. It's
no, he's not a sob sit.
Yeah. So yeah.
Yeah, but yeah, we all know he's wrong, and the guy in his ear that's upsetting the judge, this is we might as well just call him Judge Happy. He's just always laughing. Every day he's on the bench, he's just having the best day of his life, and that's why I enjoy watching him. This is why this is rare when you have. Say that again.
Living his best judge life. All right.
He is. He absolutely is. He doesn't have a fence.
Well, not everybody can be that lucky.
No one ever. Yeah. Right.
What about January?
I've been withholding since December.
Okay, so December, January, February, and I'm assuming March rent too?
Yes.
And am I right in saying that the monthly payments were $650? I just want to make sure I got. Okay. And you're telling me that you've got that money held in some account someplace?
Yes.
I can see. Did you file a written notice that there was some problems with the property?
I have text messages about everything, and I've waited months to get stuff done sometimes.
I see. And what kind of response did you get?
Sometimes I didn't get a response at all.
I see. Mr. Fanous, I don't want to take over for you. What do you have any questions for Mr. Naylor, I guess?
Judge, no. I mean, he's withholding rent. This is not an action to recover rent. We're not asking for money. I think there's nothing been substantiated that this isn't a month-to-month tenancy. We're simply asking for a rent issue in 10 days. If Mr. Naylor doesn't want to live there, he can just move. There's no action against him other than just seeking possession only. There's no money being sought. There's nothing that's been proffered before the court to challenge either the month-to-month tenancy or the notice. Notice is proper. I think it's just a rather easy decision. Mr. Naylor.
It's a retaliatory eviction,
Sir, how's it retaliatory? You got to help me out. How's it retaliatory? You haven't given me any evidence that there's any
I told him I've got so much evidence right now, and the NDB does not even own this property. It does.
That is a legal term. I've got so much evidence right now that's legal. Like the judge is like, oh, he's got a lot of evidence. Okay, we got to hear him out now.
I'm looking at the search records right now. It's NDB LLC is listed as a property owner for that property.
I have the register deeds right now. The rejection letter.
Sir, I'll give you the end of the month to move.
The rejection letter.
That's not the register of deeds, sir. That's the licensing agency.
That's the
You are
register of
incorrect,
deeds.
sir.
That's the register of deeds.
No, it's not, sir. That's Laura. That's a licensing agency for Michigan.
The register of deeds already.
Sir, that didn't look like it to me. You keep trying to get advice from somebody that's not an attorney, I suspect.
I'm trying to get the.
Yeah. Sir, are you an attorney?
No.
Then you got to keep your mouth. You got to.
So was the address. The legal description was wrong, but so was the address.
Mr. Naylor, whoever's with you has got to keep their mouth shut because otherwise I'm going to find that they're practicing without a license. Okay? I've asked 3 times to have them shut up. And what you showed me on the screen is not a register of deeds screen.
Can I show you again?
Sure. Go ahead. Show us again.
Got to turn the screen around.
All right, I'm going to fast forward about 10 seconds. He's showing his phone, and there's an address on it, and I don't want his address. I don't know if it's his address. I don't know, but I'm just going to fast forward a little bit. But that's what he's showing, and if I skip the part, yeah, the judge, I think he says it right now. He's like, no, that's Laura. That's not the register of deeds. Like, you're on Laura right now.
That's the licensing agency. That's not
It clearly states that NDB does not own this property. It's a rejection letter.
It's clear. I mean, it's blurry.
From the register of deeds. They gave us just because they didn't really know what to give us.
Showing me there is for the licensing department. That's Laura.
Well, when can I submit evidence to the court?
Today. It was today. Quite frankly, I've had a chance to review the lease. Mr. Fanous, anything else as well from your end?
Nothing further, Judge.
Fine, the complaint is in order. Summons and complaint are in order. I did get a chance to review the lease that was attached to it. There are no discrepancies in what the defendant has stated with regard to the lease agreement.
The lease is fraudulent. I never printed my name. I only got 1 page of that lease. They stapled 2 other papers to it.
Very minimum, based on what I see with this lease agreement. If there's no lease agreement, it's still a month-to-month lease agreement then. Find that there's a month-to-month lease based on all totality of the evidence. I'll allow a writ of eviction after it. But Mr. Fanous, you're still willing to give him 30 days?
Judge, I think I told him I'd give him to the end of the month, so I would say April 1.
Okay.
For a writ.
Grant a writ of eviction.
That's where they get it Wilson from because the lease is fraudulent. They did that themselves, Your Honor.
April 1st.
Thank you, Judge. I'll submit an order to the court to that effect, notating
Your Honor,
compliance by hearing.
Your Honor, can I speak?
You did.
Okay.
You did. And quite frankly, part of what you're saying is deceptive. Okay. Well, we're going to have to go first.
Can I appeal?
Good luck to you. Okay.
Your Honor, can I appeal?
You can, sure. You can appeal.
Okay.
10 days.
Mr. Funes, if you'll draft that for me, I'll sign.
I'm taking care of it for you right now, Judge.
Okay.
Yeah, that guy. It's a fraudulent lease, Judge Slavin. I didn't print my name. I always signed it. It's fraudulent.
Well, I mean, whether or not it's fraudulent, what I'm saying, he might be correct, but just not defending himself in the best way. This is why, if you can at least get with an attorney, get a free consultation. If you don't actually own the property, then you don't have the power to lease the property. And if you don't have the power to lease the property, why were you giving me a lease? So that sounds like fraud or fraud in the inducement, because you don't actually own it. It's kind of like, hey, I got a bridge in Brooklyn I want to sell you there, Colin. But I don't actually own.
I've already got two of those. I don't need a third one.
Oh, so well, okay. Well, then let me interest you in some, ocean front property in Arizona. So that it might be fraudulent on that grounds. What he was showing was Laura, which is the licensing agency of the state of Michigan. Like, if you want to look up and see if a nurse is registered as a nurse, if a business is registered as a business, or what their DBAs are, you can find all of that, and that way you can find who the registered agents are, so that you can serve them. The Register of Deeds is a different website, but see that's a case where when I have situations that are like this, where there's going to be documentation, I don't like this. I don't like that. Hey, can you see that? No, you know what? Everybody come on in. Everybody come on in so we can look at it, and everybody can pass it around. We can all see what we're all talking about. And then I can, voir dire people about it, ask them follow-up questions. Because if he doesn't actually own the premises, how are you renting the premises? Now, maybe he's a management company. So maybe I rent from Colin, but Colin doesn't actually do it. He has cooling management. There's a company called Colin Management, services, and they handle all of Colin's properties. He pays them, and then they rent it out. So there's a separate thing that they would come in and go, he's our agent. Basically, we hire this company to do all of our maintenance and all of our management and renting and collecting the rent, and then they just send you a check at the end of the month. If you get that good, where you own so many properties where you have to hire a management company, hey, you're doing pretty good. But so then in that situation, you'd still want to know, is there an agency? Does Mr. Crow actually hire this company, and then that company enters into leases with people? And sure, but just you can find all that out. As far as the signing versus printing thing, any interest in land has to be. This is why a lease needs to be in writing, because the statute of frauds. The statute of frauds has a list of things that have to be in writing. If you're going to answer for the debt of another, it has to be in writing. You can't say, well, he said he'd pay for it. Do you have that in writing? No, then he's not paying for it. That's so one of the things is any interest in land. That's why you need a deed, because your deed has to be signed by the grantor. It doesn't even need to be signed by the grantee, because it's not the grantee's property. The grantor's property is what he has to sign. So in a lease, you got to make sure that the parties sign the lease, because that you're giving somebody an interest in land. So it needs to be in writing. Now, what if it's not in writing? Michigan, that's what they were talking about. He said, well, even if the lease is bad, there still would be a lease, because he's what's known as a holdover tenant. That means the lease expired, but yet you still live there and you still keep paying, and they still keep taking the money. It automatically creates a month-to-month lease. And all you got to do is give 30 days notice. 30 days notice that I'm going to raise the rent. 30 days notice that you need to get out. 30 days notice that I'm leaving, and I'm not renting from you anymore. That's all you guys got to do. So when you don't have a lease, the problem is they can raise the rent every month. All they got to do is give you 30-day notice. So you got nothing to protect you from it increasing. When you enter into a year lease, at least you know you're locked in for a year at a certain price. So that's what he meant. The signing of it wouldn't. He printed it. His name's on it. You can print or sign. So.
All right, that's fair. That's fair. You got a little bit more time. There's probably about 10 minutes left of this video. I think I got a couple small clips, and then we're gonna finish with the one I kind of teased earlier. But I do want to read some of these super chats.
Yeah, for sure.
I'm pretty sure I read this one already. I read that one already. Chris Engelby, thank you so much for 1 month membership. That's awesome, buddy. Thank you so much, and a $5 super chat from the same person. And while I'm on this, I got a PayPal last night, and I may not have said thank you, but Louise, if you're here, Louise, thank you so much for the PayPal last night. I did read it off last night. I may have been on mute. That may be why you missed it, but I didn't miss you on purpose. It wasn't intentional, so I'm sorry. And here's another shout out, but thank you so much. And yeah, she had a joke about the sharks with laser beams, and it was funny. All right, let's go. Now I think we're going to the smoking guy. Yeah. So I went ahead and covered this guy in the bot underneath the judge, just because this guy he's kind of my hero. I'm not gonna lie. With that beard, backward hat, and not only that, he is smoking a cigarette while the judge is talking to him, and the judge just like, you know what, I don't care. Your case is dismissed. Just go. But this guy, just his attitude, he just has this attitude that's kind of contagious.
All right.
Yeah, once it starts, playing.
Let's see. Do I have let's see, Jonathan Emmendorfer. Sir?
Yes.
Your man.
Not only does he have a Viking beard, that is an epic name.
It does.
That is an epic name. Oh.
What is that?
Emmendorfer.
All right.
Emmendorfer. Here. I'll full screen it just so you can see it a little bit better. Take us out of it. Oh, I got to drop Therina. Sorry, Therina. I got to take you out. Thank you so much for the 2 months.
Yeah.
There you go.
Yeah. All right.
Your matter's been dismissed.
Okay, I was just making sure that they did dismiss it because I paid the rent and I paid the next month's rent. And I'm working on paying this next month's, but my boss hasn't been able to pay me because the economy is so bad that he hasn't been paid money to pay me for this month. So this whole month I haven't been paid for work I've done.
Well, it looks like you're working on it. So one way or the other, at least it's been dismissed. They have to refile if they're going to do that. So you're all set.
Okay, well, I've already talked with the manager, and she even gave me an option, said if I clean my place up, she'll paint it for me.
Wow.
So I cleaned my place up, and now she's going to paint my trailer for me. And
hey, that's not a bad deal. Everybody can cleaning, man. That's the way to do it. If somebody came over and told me that if I cleaned up, they'd paint, that'd be good for me.
Oh yeah, it saved me like $100 in paint.
Yeah, you're right.
Paint's pretty expensive.
Yep.
But, I'm doing my part in this trailer park to fix up other people's trailers as well.
Good.
So
I appreciate the effort, and we'll it's just dismissed, so you're all set.
All right. Well, I'm just glad to not be wearing orange today.
Good. Good. All right. See you later.
All right. Maybe next time.
All right. Hope not. How about?
I told you that guy's just charming. He was charming.
Nice.
Look at that. No idea.
He's got that Riz.
Yeah,
he's got that
He
Lieutenant Riz. There you go.
He does. He walked in there. He owned it. Had the Viking beard. Had his hat on. He was smoking in the judge's face, and the judge was like, "You know what?" After that last case, I think I don't know if that was exactly after the last one that we just watched, but it was within a couple minutes. And the judge was like, "Thank you so much for bringing the smile back to my face." All right,
he just needed a horn to mug.
Right, he did. All right, the next one is just about a 30-second case. The judge is going to try to call on this person that's sleeping.
And how about Goodlow? Do I have a Goodlow? Lorraine Goodlow.
Yeah, she's out. She's out.
Lorraine Goodlow. She's taking a nap. That one's dismissed too.
It's dismissed.
Yeah.
Just cut her right out. It's like it's dismissed. It's
that happens. I mean, it's you try to watch out for it. I mean, it does get. You want to make sure we give access to justice, give people an opportunity. Because I'll tell you what, in the landlord-tenant cases, the amount of defaults where people didn't show up to court and they just lost because they didn't show up has gone down dramatically with the use of Zoom. So at least people can show up for their court, argue on their behalf, participate meaningfully in the proceedings. And that's what ideally, that's what's paying deference to the Constitution. That's what's paying deference to due process, that people can participate. Not just that you set up a system, but that people can participate in the system. But at the same time, you're cozy in your own house, in your own bed. There's a certain amount of you wake up a little bit when you have to go outside and it's cold out and you got to drive to court and get in there and walk in there. And there's a bailiff and everybody else looking at you, so you don't want to fall asleep like you do in church in the pews. And so you kind of stay a little bit vibrant. I've had people fall asleep. I've seen jurors fall asleep. I'm like, get the bailiff to wake that guy up. I mean, if I was a defendant, I'd be like, dude, wake up. I mean, this is my life on the line. You mind? I mean,
you got just buy a couple disposable gavels and just start throwing them at the jurors.
What you need is those squeaky gavels that like squeaky.
Yeah, exactly. Or just get Thor's hammer as your gavel so you can throw it and bring it right back.
There you go.
We're on the same page. I just went Marvel and you decided to go Australia.
We're going to Shark Tank those gavels.
We're going to go to Shark Tank with like 13 ideas. What do we got? We have the Uber helicopter. We just we just got to find someone with a helicopter and a helicopter license.
That's right.
All right, we're going into the last case. The last case, it's a fun one. This is the one I kind of teased earlier, where the judge kind of just starts laughing at the guy. All right, let's go. No, I didn't tease this one. This is a different one than I teased, but it's the same judge. I was in my head, but it's not the same
There's
case.
star six on. Well, not star six. Okay. All right, take off your hat for me, sir, please. All right. Now calling the matter of the people versus Edgar Lewis Watkins Allen Jr. This is ticket SP 13644.
Dorina, thank you so much. I know I kind of called you out, but I was like, Dorina, get off my screen. I want to show this guy. I want to show Judge Slavin this name. Thank you, Dorina. You're awesome. A member of the Twat Waffles. Dorina, you're awesome.
70. Count 1, drive a registered untitled motor vehicle. Count 2, no insurance misdemeanor. Count 3, drove while license not valid or improper. Ticket SP 1321711. Count 1, drive while license suspended. Count 2, no insurance misdemeanor. Count 3, drive a registered untitled motor vehicle. Ticket SP 1309709. Count 1, drive unregistered untitled motor vehicle. Count 2, improper plates. Count 3, no insurance misdemeanor. Ticket SP 1241261. Count 1, drove while license not valid or improper. Count 2, no insurance misdemeanor. Appearances for the record.
Yeah. When it takes you more than a minute to read all the charges, do you just? I wish there was like a fast forward button. So you're reading all of it. You know what? You've got a lot of tickets. So we're just going to say you have a lot of tickets.
Yeah, but you have to be put on notice of what you're being charged with, and that's
I know.
I know, and it seems redundant. I mean, hey, listen, you're talking to the guy who has to say the same thing.
I hear you say it 37 times a
day. So, but you got to remember why you're saying it. And if I had a doctor, if you went to your doctor, your cardiologist, and he was just like, yeah, you got to do this and then you do this, you're like, whoa, what? Hang on. I thought I heard die. What's going on? Like, you want to know, you can't breathe. You're having hard problems breathing. You have chest pains. Can you slow down there a minute and explain everything? Same principle, but from a legal perspective instead of a medical one. So I'm sure
That's
that doctor wants to get in there and throw it all out there, and I'm sure you want to get into your auction voice and be like, "Hey, now I want to baby, look at this, I want to look at 5 over here, 5 over here, look over 10." I mean, you don't want to. You got to just slow it down and make sure they understand.
You may have missed your Colin. Just saying, you're an awesome judge, but that was pretty good. It wasn't legible. No, not legible.
No,
no
I
one
think
understood
that's
what you
what-
said, but I think that's the point, right?
Sure. There you go.
Everyone understood $5 though. Everyone
There
understood
you go.
$5.
5 and then 10. You know, there you go.
All right, let's go.
Starting with counsel, please. He
Good
does have a
morning, Your
valid
Honor.
license.
Harry Bachman for the defendant.
All right, sir,
State your
state your
name,
name
sir.
for the record.
I'm laughing because I know where this goes. Just spend a minute reading out tickets and then the defendant attention.
Oh, this is all about them, and they'll be paying no attention. You know, I call 20,000 cases, Attorney Boffman. You think you would be paying attention?
Is this Mr. Watkins Allen?
Yes.
Now he says yes.
Attorney Balkin, I can't take it tonight. I'm losing it. He is not even. That's because he's riding in the car. I hope he's not driving. Well, he can't.
No,
He has
I'm
a
not
valid
driving.
license. But still,
Yeah,
he not even. I done called and used all my good morning breath to
I'm
call
sorry.
his 1, 2, 3,
All of it,
4,
sir.
5 tickets with each one being filled up, and he's sitting there like this.
No, I'm sorry, I didn't hear you.
Okay. So Harry Bachman for the defendant. State your name. Thank you.
Did you completely ignore it?
I'm glad they all fall on one day, Attorney Boffman. That way,
Thank you.
my patience level can be tested that one day and none other. His license is valid, though, Attorney Boffman.
Nice.
So how are we proceeding with this?
So with a
All right, that's all we need to play. Everything else is just basic court. They dismiss a lot of his accounts. He does some of them. That's pretty much what happens because he got his license, he got his insurance, his car is registered, so they dismissed a lot of those tickets. But it was just funny. That was funny. I just wanted to end with a laugh. That's what I wanted to end on.
There you
go. Yeah. We're gonna call it a night. It's been over an hour and a half, so this has been a longer stream than normal.
Sure.
So
I don't know if you had any questions or anything like that, but
yeah. Does anyone have any final questions? We used to like keep some of the questions for the end of the night, but this was a surprise stream, so
it was.
Yeah. And that was his idea. This guy right below me, this guy right here, his idea. He's like, let's do it just surprise, you know. Then no one will see what's coming. No one will know what's coming.
Jump in, freestyle.
Yes. Yeah, you don't want me freestyling.
It's like epic rap battles of, epic legal battles of history.
Epic legal battles. Colin was slaving.
There you go.
Anybody have any last questions before we say goodnight? We will jump over to Discord and hang out after this. But if anyone has any questions, yeah, you got a minute, and then we're gonna call it a night.
All right.
Yeah, thank you so much for jumping up. Thank you so much for being part of the channel. I know I say thank you to you every single day, but now it's public, and I think the last time you were on, I didn't say thank you at the end of the night, and I got called out for it. It's like I email him, I message him, like he knows I'm thankful. Everybody, he knows I am.
My privilege.
All right.
Privilege. Have a great night, everybody. Yes.
No, we got one.
Modern or old? Let's see. I like a classic 65 Mustang. I also like the Porsche 918 Spider. That wouldn't be bad to have. So yeah.
Nice. All right. Here's one. Here's a judge-related question. I know you've answered this opposite thing a few times, but Annie may not have been a part of those conversations. So
sure, Annie. Good evening. The sob sit stuff, like I've said before, has its grounds and its basis in half truths. See, that's so it kind of boils down to like a little bit of information can be dangerous. So people take things out of context, or oh, you got a flag that has a yellow fringe. You know what? It doesn't mean anything. So they just try to make things mean things. I think with educational, and I say educational programming such as this, people will, because people go on the internet, I think, and they initially say, "Oh man, I got a case. I can't afford an attorney. I don't know what to do." And they're like, "So how do I win whatever case?" And then these videos will come up that'll be like, "Listen, all you have to do is become a Moroccan citizen, and under the Treaty of Peace and Friendship, you are going to be dismissed of all cases." Yeah, no, that's not how that works. That's not how that works. Now, is there a treaty? Yeah, absolutely. Is the embassy in Morocco literally the longest standing treaty that like the United States has with another country and an embassy that has existed for a long, long time? Absolutely. So, but it's not. That's not how it works. And so, I think eventually people are just going to find out that being the beneficiary of the all caps name and you are just a trustee, and you are just a trustee for said estate, and you appear sui generis and this and that and juicy fruit gum and all the other stuff that you want to say isn't going to do anything for you. And I think that they people will start to realize that because they'll see, from videos like this that no, that's not actually how it works. So that might be where that stuff goes. It might die out, but I think people are just gonna also just keep trying it. Why? Because some people like to be the class clown.
It's also true. It's also true. All right, got one.
No, that's a no. Legal fiction, it tastes good. It's just so horrible for you. Go with the real butter. Real butter is actually, it's probably better for you. I don't know. I'm not a doctor. But I think it's better for you to just have real butter than the plastic fake, some sort of hydrogenated oil thing, whatever stuff. So yeah, and it just tastes, but it just tastes better. So you might as well just go for the real deal.
You might as well be using mayonnaise at that point.
Yeah, it's either motor oil or mayonnaise. We'll go for one. No, you can use mayonnaise though. I mean, you can grill in it, but I seen one thing where they use butter on the outside where it's grilling and mayonnaise on the inside while it's grilling.
All right.
So
I don't love mayonnaise that much to put it on a grilled cheese, so I won't do that. But yeah, that makes more sense than putting mayonnaise on the outside of the grilled cheese.
Well, you got to show some love for the mayo because it's one of those bases that you can change it into tartar sauce. You can change it into a bunch of different things. Add mustard with it, and then there you go. Boom. I mean, you can do all kinds of stuff with it. Add some ketchup to it, and then some pickle relish, and you'll have whatever sort of mac sauce ish thing you got going on there. So
no, but that's what it is. Mayonnaise is the base for almost. I'm going to say probably 50% of the sauces out there, and salad dressings, mayonnaise the base
for sure.
I can't the ungodly amount of mayonnaise that you put into ranch dressing, blue cheese dressing. It is 90% mayonnaise.
It's true,
and just a few seasonings, and it makes the ranch. Ranch is almost 90% mayonnaise. You're eating mayonnaise.
No, that's buttermilk. Buttermilk.
No, it's like
the original buttermilk
like 3
ranch.
parts. 1 part ranch, 1 part buttermilk, and then some dill, and there you go. Salt, pepper, garlic. But yeah, pretty much that's what it is.
Nice.
All right. I think we're gonna call it a night. Thank you so much for hanging out.
Absolutely. Always a lot of fun.
Vote your buddy behind you. I see your sign.
Oh yeah. That's from a couple years ago.
Oh, it's a couple years ago. Okay.
Yeah.
All right.
Not sure if he's running this year. I haven't talked to him about it.
Well, everybody have a great night. Judge Livin, thank you again. I'm going to jump over to Discord. Judge Livin, have a good night. I cannot wait to watch you. Just do your job tomorrow, and maybe we'll get something good.
Hey, as long as this dispensing
Don't
justice.
comment. Don't comment on that. Don't comment. All right. All right. Have a good night, Judge.
Yep, me too.
Now I just got to figure out how to put up my outro. Not used to doing it this way. Let's go. Get to see me searching. Here we go. All right. Bye, guys.